New York State Court Judge Juan Merchan responded in a fiery order to Donald Trump's attempt to claim absolute presidential immunity in the Manhattan District Attorney criminal case. Karen Friedman-Agnifilo, former number 2 at the Manhattan District Attorney, I want to get your take here. Donald Trump is seeking to adjourn this trial date, which is scheduled for March 25th. Trump is trying to recycle these arguments about absolute presidential immunity for a lot of the conduct here. Most of the conduct took place before Donald Trump was ever even in office, and Trump's trying to essentially claim that his attempt to cover up the crime while he was in office serves as a way to give him immunity for the crime itself, since all of that evidence, he claims, should then be excluded from the trial. So he says, at least delay this trial and possibly just throw this case out. Let's take a look at what Judge Juan Merchan put in this order. Then I want to get your take, Karen. Judge Merchan wrote, trial on this matter is scheduled to commence on March 25th, 2024. Although the deadline for motions in limine, which are pretrial motions, was February 22nd, 2024, defendant Donald Trump yesterday filed a substantive motion seeking, among other things, an adjournment on the grounds of presidential immunity. Defendant does not explain the reason for the late filing, a mere 2.5 weeks before jury selection is set to begin. The people have been granted until March 13th, 2024 to respond. Effective immediately, the parties are hereby directed to obtain leave of the court before filing any additional motions prior to March 25th, 2024. A party seeking such leave must file a letter pretrial motion with the court, no more than 1 page in length. The pre-motion letter must set forth the basis for the motion and the relief that is being sought. The opposing party will be given 1 day to respond should it choose to. The court will then grant or deny the request. If leave is granted, the court will notify the parties of the briefing schedule. In appropriate cases, the court may exercise its discretion to construe the pre-motion letter along with the opposition letter, if any, the motion itself, as the motion itself. The foregoing constitutes the order of the court. Signed, Judge Juan Merchan. Karen Friedman-Agnifilo, what do you make of this?
This is as frustrated as I've ever seen Judge Merchan be, is this particular order that he did, because it's kind of outrageous when you think about it, what Donald Trump is doing. Everyone knows that Donald Trump's entire legal strategy is to delay and not ever have a trial in any of his legal cases. And so we've all been waiting and wondering and even taking bets on what tactic is Donald Trump going to try to use to delay his case, because he doesn't want to go to trial. He claims he's innocent, but he has no interest in actually testing the evidence before a jury, cross-examining witnesses, and proving his innocence, right? He has, or he has no obligation to prove his innocence. Obviously, the government, the people have to have the sole burden of proof to prove beyond a reasonable doubt, but test them, push them to hold them to their burden, right? He has no interest in doing that. And so we've been sort of talking behind the scenes and taking bets. And Ben, you called it. You said this was going to be the thing he did. He was going, the minute on February 28th that the United States Supreme Court granted cert on the presidential immunity claim, you called it more than almost anybody else, that he was going to try to use that as a basis for delay. And I think the reason many people didn't quite see what you saw, that this was going to be the basis to try to seek delay, is because it has zero legal merit. Okay, zero. This is a state court case that for conduct that happened in his personal capacity, right? He has a personal lawyer, Michael Cohen, at the time. He was campaigning, right? He was candidate Trump. He had this had nothing to do with his presidency. There's, unlike the other actions that he's accused of, whether it's Mar-a-Lago and the documents or Jan 6, that there is a least somewhat of a straight-face argument you could make to say, oh, I was acting as President Trump, even though he'll lose there too. But this one doesn't even come close, right? This one doesn't even if you strain your brain to think of it, you would never think that this could be presidential immunity. Yet somehow, Ben, you have gotten so good at knowing and predicting what Donald Trump will do that you knew that's what he was going to do here. And so you were right, he did it. But this order that Judge Merchan points out is the deadline for these motions is February 22nd. Now, Donald Trump will say, yes, but the Supreme Court didn't grant cert until February 28th. Well, and that's the difference. Okay, that was 2 weeks ago. What have you been doing for 2 weeks? If that was the case, why didn't the day after that, right? It was a leap year, so February 29th. Why didn't you say to Judge Merchan, given the recent events, I'd like an opportunity to file another motion. I'll have it to you in 2 days' time. And the reason he didn't need 2 weeks to write this motion, although it's substantive, as Judge Merchan points out, the arguments are recycled old arguments that he's been using in every other case. The only difference is there was no way to stretch the facts to try and make it so that he could argue that this conduct was during his presidency was presidential in nature. So because they couldn't come up with an argument, they finally stretched the facts so much that they said, you know what, I know, let's say that we can't say that the crime happened, that was within your duties when you were filling out your personal checks to your personal lawyer and then recording those in your personal business records. We can't possibly say that was presidential. But you know what? When you had a Twitter account and you were tweeting while you were president in 2017 about this case, about Michael Cohen, about Stormy Daniels, and denying that it happens, that was a presidential Twitter account. That was an official United States White House Twitter account, the real Donald Trump or President Donald Trump or whatever he was going at the time. And therefore, that was presidential. And when I talked, there were statements and because there are some tweets that the people want to use in their direct case, there's also some statements that Donald Trump made to the press that they want to use. And he's also saying, well, again, those were White House press reporters who were asking me questions while I was president. And so that's presidential too. So it's the evidence, it's 2 or 3 tangential pieces of evidence that the people don't even need, by the way, in their case to prove this case, but it does provide some color, but it's certainly not essential to their case. And it's certainly not even anything remotely necessary. It's relevant for their case. He's stretching it so much that he had to put that in the argument in his motion paper. But again, it's 2 weeks later. And so the judge is pissed. The judge sees right through it, and he sees that Donald Trump is just trying to delay and basically saying, without saying it, there's no excuse for this ridiculous delay of 2 weeks here. And so, by the way, I'm going to give the people 2 days to respond. I will then rule. And basically he smacks them down and says, and if anyone wants to do something like this again, you have to get permission first because we're not delaying this trial. And so this is Judge Merchan really putting up guardrails and saying, we're starting March 25th. Everybody's gearing up. The DA's office is gearing up. Everybody's getting ready. This is happening. And stop. I see what you're doing. So stop. And that's what this is. This response, this very quick response that he gave, that he rendered very shortly after Donald Trump filed this ridiculous motion.
No, we said it in the last duet you and I did together. Donald Trump's argument is essentially you can rob a bank, you can kill somebody before you become the president. And then when you try to cover up your crime, the cover up cloaks your crime in absolute presidential immunity. That's how absurd Donald Trump's argument is. In terms of why didn't Donald Trump wait until February, or why did he wait until now, and why didn't he file or seek some relief on February 29th after the Supreme Court granted certiorari? Because Donald Trump is not trying to follow the rules. He's trying to break the rules. So, Karen, when I was predicting what he was going to do next, my theory was, what is the illogical rule-breaking methodology here and not the law and way about it? So if you're trying to break the system, what would you do? And my thought is you'd probably wait right until the trial's about to start to create all of these issues and to try to create these problems and to try to blow up the trial, because you're not actually vested in our justice system. You're vested in destroying our justice system. You layer on top of it not just the absurdity of Donald Trump's argument of claiming absolute presidential immunity for criminal conduct of paying adult film stars hush money payments and then covering it up in your books and records with fraudulent financials before you were in office and trying to cloak that in absolute presidential immunity. If that isn't absurd enough, a federal judge in New York, federal Judge Hellerstein, has already ruled that Donald Trump expressly waived absolute presidential immunity when Donald Trump tried to remove this matter, the criminal case, to federal court. Go back to some of the hot takes we did when Donald Trump tried to get this case and there was oral arguments before a federal judge. Trump tried to get the Manhattan case in federal court, and Judge Hellerstein ruled on this issue of immunity. So there's a doctrine already, in my view, called collateral estoppel, where Trump's stopped from making this argument, and Judge Hellerstein ruled the following. In this case, Trump raises an immunity defense. Trump has expressly waived any argument premised on a theory of absolute presidential immunity. And if Trump disagreed with that, he could have then appealed that to the Second Circuit and then brought it to the, and if the Second Circuit didn't rule his way, petition for certiorari then. Trump did not. So there's this whole other issue of waiver right here. But let me tell you what I think Trump's going to do. And then, Karen, let me give you the final word. Trump is looking for a Hail Mary stave from the Supreme Court. He knows he'll lose from Judge Juan Merchan. He will file all sorts of writs and you name it, he will file it. And then he's going to try to get this before the Supreme Court. Trump's going to argue, look, we have certiorari on the other case, a Washington, D.C. federal criminal case, April 25th. And Trump's going to say, here's my prediction, just why don't we merge this with that case? We'll hear it on April 25th. And then we can delay this trial. He's going to do everything he can to try to delay this, and he's going to try to beg the Supreme Court for a favor here. I just think not only is the judicial system, wising up at the state court trial level to Donald Trump's antics, but more significantly, Karen, I just see a whole momentum change going on within the American people right now. I think who are fed up, and I'm not going to spend this hot take talking about how Donald Trump's 20-year employee, Brian Butler, went on and did this interview with Caitlin Collins on CNN about hearing Donald Trump give like nuclear secrets to guests at Mar-a-Lago. But a lot of this information is beginning to reemerge right now. And I think have new context, especially following President Biden's powerful State of the Union, where I think the American people are looking at this and saying, we need to really get serious about this threat right here. And the same way President Biden looked at the United States Supreme Court and scolded them for what they've done in taking away women's reproductive rights and saying, you will see the power of women when it comes to 2024. And you saw the Supreme Court. I just think the American people are fed up with them as well and see what's going on. I'll give you the final word, Karen.
Ben, your ability to understand a criminal mind is a little scary. So I hope you always stay on the side of good and continue to wear the white hat. I always thought that Donald Trump would try and delay things by creating a conflict with one of his lawyers, threatening him or something like that, because that would have to delay to seek a new lawyer and to try and find a new lawyer to get up to speed on the cases. That was my prediction, but I'm clearly not as good at thinking the way criminals who are trying to get away with with things the way they think as you are. And I agree with you. I think the more witnesses who are coming forward and speaking out on trials that will never happen, like the Mar-a-Lago case, because he's got Judge Cannon doing his bidding, et cetera. I think the more normally you would say witnesses should wait for the trial, but that's not going to happen in that case. And so the more witnesses who will come forward and tell their story, the more I think the American people will at least have an opportunity to know what Donald Trump did before they cast their votes in November.
Karen, thanks as always. Karen Friedman-Agnifilo from Legal AF. Hit subscribe. We're on our way to 3 million subscribers here. We appreciate you watching. We'll keep you updated as we learn more. Have a great one.
Hey, Midas Mighty, love this report? Continue the conversation by following us on Instagram at MeidasTouch to keep up with the most important news of the day. What are you waiting for? Follow us now.